this is in the matter of Mr. Klein. There's some guideline argument first, so you can have a seat for now. All right, this is in the matter of the people of the state of Michigan versus Jake Gordon Klein. We have file number 23-21225FH, 23-21223FH, 22-20712FH, and then we also have file number 2013-39368DS, and that is in the matter of Hannah Gies versus Jake Gordon Klein, and that is a DS file. So, Miss Underwood and Miss Muir, and Miss Underwood on behalf of Mr. Klein and Phoebe Muir here on behalf of the people. You obviously both received the pre-sentence report because I did receive a people's sentencing memorandum and then also a response that was filed by Miss Underwood. So, I have my guideline book, I have the sentence report. So, Ms. Underwood, have you had an ample opportunity to review the pre-sentence report with Mr. Klein?
I have, Your Honor.
All right, and Mr. Klein, have you had ample time to review it with her and ask questions?
Yes, Your Honor.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy, I'm not talking guidelines, of anything in the pre-sentence report?
Just a couple of things, Your Honor. Let's see, there was, I believe there was reference made to drug use, and Mr. Klein denies any current drug use, Your Honor.
Oh, okay. And he said that, he denies it. I don't believe him, but I understand that he denies it.
Thank you.
Okay. Anything else in the body of the report? Miss Underwood.
Any reference to a damage to someone's vehicle, Your Honor? I don't believe charges have been brought. And
okay, it was where somebody indicated that their tires have been slashed, but there was no proof or any video or anything indicating to prove that it was Mr. Klein.
And Mr. Klein denies that.
Mr. Klein denies it. So there was a statement in there that there was a claim, well, someone's tires were slashed, but there was no way to ascertain whether or not Mr. Klein did that or not. Do you know that sentence?
I do, yeah.
Okay. So
and all I can say is that's still under investigation by the Clinton Police Department.
Okay. So for purposes of this pre-sentence report, we'll strike that line.
Thank you.
Because of that. All right. Anything else in the body of the report?
No, Your Honor.
Ms. Muir, anything in the body of the report?
It was addressed in my sentencing memo, but I think there was just a typo as to the restitution amount.
Okay.
But again, that was addressed in the memo, and I think defense agreed to that.
Okay, and restitution should be $4,096.46.
I don't believe so.
Not 4,596. And then
yeah.
That was the one that was a correction, right?
Yeah, that's the only one that was corrected, and otherwise I just laid it out, broken down per victim and filed for the court.
Okay, no objection to that.
Well, I've explained to Mr. Klein that the numbers in there, he has a right to a restitution hearing.
Absolutely. But for purposes of that being in the report, in order he can still have a restitution.
I would not object.
Okay. All right. So on the guidelines that I received attached, the guidelines on each of these files were 0 to 9 months. I received a sentencing memorandum from the people. Let me go to the first one. Statement. Okay, so the first one. Okay, so on file number 23-21223 FH, go to that file. Ms. Neer, you're arguing that OB for psychological injury to a victim, which was scored at 0 on that file, should be scored at 10. Is that correct?
Correct.
And you make that argument.
I'll rely on my sentencing memo, Your Honor. I would make, I guess, an objection or a correction to defense's response. They incorrectly stated that Mr. Kelly did not give a victim impact statement when in fact he did. In addition to his victim impact statement, I believe he is one of the individuals here ready to speak today before the court. But the statement I'm relying on for this to be scored is in particular that he does have a loss of sleep. He worries that the defendant will come back and cause harm to the family. As the court is aware, scoring this offense variable does not require that they actually seek treatment, just that there is a psychological injury. I don't know that I cited any cases, but if we look through our guideline book, there's a number of cases that are cited that have very similar statements that they've upheld scoring in this instance.
Okay, Ms. Underwood?
Your Honor, we believe OB4 was properly scored in the guidelines. This is an embezzlement conviction, Your Honor. There's no, the victim did not seek treatment. And we understand his concerns and financial stress, but we don't believe they rise to the level of psychological damage necessitating a finding, Your Honor, and I believe the probation department didn't either.
All right, well, the Court of Appeals held that there was no error in scoring 10 points for OB4, where the victim impact statement reflected that the victim felt angry, hurt, violated, and frightened after the home invasion offense in that case. People v. Williams, 298, Mish App 121, 2012. So in this case, we have a victim impact statement where Mr. Kelly stated that I'm not able to sleep after Mr. Klein got out of jail. There was injury in my car every night. I wonder who will come next and what will happen. Only get to feel like I can go to sleep is in the morning when my family's awake. Lack of sleep and worry that he would come back and try to hurt my family more. So I feel that we have enough on the record for purposes of scoring OB for it.
Your Honor, I would just distinguish between a home invasion and an embezzlement case.
Was this
Where this defendant did actually go to the victim's house to accomplish this crime.
wait, did I read for the wrong victim impact statement? Probably.
No, you read from the correct one.
Oh, okay.
Yeah.
I'm saying the case cited was a home invasion case.
I understand, but I'm
Mr.
willing
Klein
that it
did
applies.
not invade their home.
I know,
Yeah, but
it doesn't
that's
have to
also
be the
not-
same offense for precedent. It just has to be the same response. And I think that's satisfied here. So I will score OB for it. All right, so Ms. Neer, the next one you addressed was OB9, number of victims, on file number 23-21223 FH, that was scored at 0. So Ms. Neer.
The individuals I'm asking the court to consider as victims in this case are obviously Mr. Kelly and his wife as two individuals. But we also have No Leak Home Improvements. That was the employer who Mr. Klein actually did not pay. He had taken Mr. Kelly and Mrs. Kelly's money and did not give it to No Leak when they were supposed to. And he fraudulently took Mr. and Mrs. Kelly's money at that. So there's 3 victims right there. And also in the course of this investigation, it was included in this and in these charges that Ms. Sukman, it was actually a dismissed charge per the plea, but Ms. Sukman had $1,400 taken from her by the same scheme that Mr. and Mrs. Kelly had their money taken from her, or from them, excuse me. So I believe that reaches the 4 victims. I think defense argues that it is case specific or fact specific, or excuse me, charge specific, but I do think that that's what this is in this case. He was able to accomplish his crime by defrauding a certain number of people. That's how he had to accomplish it.
So you believe it should be scored at 10 points?
I do.
And that would be for 2 to 9 victims. All right.
For
Well, 4 to 19.
4 to 19.
4 to 19.
Your Honor, I would submit that no leak, Mr. Klein embezzled from Mr. Kelly, but no leak was not out anything. They didn't do any work. They were out nothing. They knew nothing about it until the Kellys went to them. So I don't think no leak are victims. And on Ms. Goodwin, that charge was dismissed. I think that the probation violation report, or the PSI, was appropriately scored, Your Honor.
So Ms. Mayor, response?
Yeah, just to clarify, it is a twofold crime here. No leak is out money because he first defrauded the Kellys by taking their money under false pretenses, but that money he took for no leak to come perform the work on the house, and obviously they didn't come perform the work on the house because Mr. Klein never gave them the money that the Kellys paid him for that. So it is twofold, and that's what makes this so difficult, because it is a layered crime here. I mean, he had to lie to the Kellys and then not give the money that the Kellys gave him under false pretenses to No Leak. So No Leak was damaged as a company, obviously, because the Kellys thought Mr. Klein was working for them and they never got their money. So he did embezzle from No Leak because the money the Kellys gave him should have went to No Leak. But the Kellys should have never given him money in the first place.
Anything else, Ms. Summer?
One side or the other is the victim, Your Honor, but No Leak was out nothing. They knew nothing about the Kellys and didn't do any work that cost them anything until ever. But they found out through the Kellys that this had happened.
So on OB9, I am going to leave it correctly scored at 0 because the Kellys are the clear victims in this case, but I think it's pushing it a little bit to score No Leak. So I'm going to leave OB9 at 0. Then we go to OB13, continuing pattern of criminal behavior. So let's go to OB13.
Your Honor, Ms. Underwood acknowledges in her response on the scoring of that, so.
All right. So OB13 will be scored at 10 points, correct?
Correct.
That's correct, Your Honor.
All right, so now we have the OBs at 20. Do we agree on that?
Yes.
No, 25. Because OB16 is correctly scored at 5, right?
Yes, yeah, that wasn't brought up.
Okay, so 25 for the OBs. PRVs remain at 22 on this one, correct?
PRVs remain at 22.
So this is Class E property accounts.
Be 0 to 17 then, Your Honor.
So that would take the guidelines, yep, to 0 to 17 on this one.
0 to 17, where,
Let me see.
on 5, or on 60.
On E. So 22 is 0 over 25 is 0 to 17.
Correct.
So PRV, if you score at 22, that comes in at a C grid, And then the OBs are scored at 25, which comes in at 3. So if you go C to 3, that's 0 to 17. And that's on 23-212235. Once we just discussed.
23.
I'm looking at the sentencing grid right now. And PRVs are 22, which is C. And then OBs are 25, which is 3, so that's 0 to 17. All right. So let's go to 23-21225 FH. Do you want to look at my guideline book? You want my grid?
I'm not sure.
I don't know what you're,
Okay,
do you want to look at the grid?
sure.
I have one, I have it right here, I can show her. 17, 22, 25, 0 to 17.
I thought there was an objection on 16.
Not one that was,
Oh, maybe she made one. Hold on. Maybe she objected. Let's see.
I might have done a typo.
there was not one, there was not an objection.
223 from yours. You did not, on that file, have an objection to
Oh, okay.
16. Maybe you had one on a different one. Okay, so let's move on to file number 23-21225 FH. Probation Department calculated minimum sentencing guideline range to be 0 to 9 months. Ms. Meir and Ms. Underwood, as I said earlier, filed sentencing memorandums. So the first objection Ms. Meir has is on OB9, number of victims. Ms. Meir?
Your Honor, I guess similar arguments, just different victims in this case. This one deals with Mr. and Mrs. Jewell, Anthony Jewell and his wife, who obviously their roof was damaged in this case. So and it was, as investigated, was man-made damage caused by Mr. Klein. They had made a claim to Farm Bureau Insurance based on the damage that Mr. Klein did. Farm Bureau Insurance is now out money based on what they gave to the Jewels. And then Family First Construction, who Mr. Klein claimed to work for, they were also, they've lost business as a result of this crime. So I would ask that the 4 of them be considered victims in order to score this at 10.
All right, Ms. Underwood?
Your Honor, as to that, we understand the Jewels are victims. We further understand that they are out. Mr. Family First, I don't see them as a victim. Mr. Klein didn't take anything from them.
Are they aware of it? Did he work for them?
Yes, sir.
They were aware of it?
And I worked for him, yes, they knew about the house and everything.
And that's yeah, we don't believe it comes up to the number of victims required to template.
Ms. Meir?
Just rely on my former argument, Your Honor.
Well, In this case, on this file, I do believe OB9 would be properly scored at 10. We have the two people who own the home, the insurance company, as well as the company that he was employed for that knew about this job in this case. So I will score OB9 at 10. So Ms. Meir, the next one you addressed on this file was OB13, continuing pattern of criminal behavior. It's currently scored at 0. You're asking that it be scored at 10. And you do agree, Ms. Underwood. So OB13 will be scored at 10. And let's see, Ms. Meir. OB16, property obtained, damaged or lost or destroyed. So Ms. Meir, your argument on OB16.
I believe Ms. Underwood agreed to that one as well. It's scored at 5 for under 20,000 and the damage is over, excuse me, 20,000. And I believe she agrees with that in her answer.
Ms. Underwood. Okay. So OB16 will be 10 as well, correct?
Yes.
So the PRVs on this file stay at 22. The OBs will now be 10, 20, 30. So
Also be 0 to 17, same as the other file.
all right. So Ms. Underwood, that'll take it up to 0 to 17 on this file as well.
Thank you, Ann.
Okay, so. That's. All right, so we have a child support failure to pay file as well. So Ms. Brenner, I did not forget about you. So we have the Attorney General's Office on file number 22-20712FH. On that file, Ms. Brenner, the guidelines were scored at 0 to 9 months. I did not receive any sentencing memorandums on these. Ms. Brenner, I'm sorry, you're muted. Ms. Brenner, you might be muted. You're muted.
Sorry, Judd.
All right, do you dispute the guidelines on that file?
No.
All right, Ms. Underwood?
No.
All right, so the guidelines in that file are 0 to 9 months. Now, before the court passes sentence, I will forward the victims to speak on each of these files. So Ms. Underwood, you and your client can have a seat.
I want to just make sure that my objection to the guidelines changing my uniform objection.
Okay.
Is on the record.
All right, so, and I will attach, that'll be part of the file, your objections, as well as sentencing memorandum, and I understand you'll continue those objections. Thank you. All right, so let's start with file number 22-20712FH. Do you wish to speak today?
Is that the,
Ms. Keys?
oh,
I'm sorry.
Yes?
Yes, ma'am.
All right, why don't you come up to the podium? All right, step up to the podium. And I know you've done this before, but can you state your name for the record?
My name is Hannah Mashinsky.
I'm sorry, Mashinsky.
You're fine.
All right, so spell Mashinsky.
Machinski.
So this is your chance to address the court on this file.
Yes, ma'am. Mr. Klein and I share a son who is 10 years old. He has failed to pay child support for many years now. I support him solely on my own. Just me, working 10 to 12 hours every day, losing time with my son, him losing time with his mother. He misses out on sports, he misses out on activities. I can't afford to do everything by myself. I'm trying. I try my hardest every single day, and I hope my son can see that. You have to work, and you have to choose the right paths in life. I came here. I didn't want to come here, but I figured I needed to speak on behalf of my son, not for me, but on behalf of him. He hurts because of this every day. He asked me, when's my dad coming back? When do I get to see my dad? That's not easy at the moment. That is not easy. And it's harder when I'm not there for him because I'm at work. I think that is all I have to say.
Thank you.
Thank you.
All right, let's move on to the next file. Who would you,
So I believe this would be in file number 23-21223, Mr. Kelly. Is that correct?
Mr. Kelly, you want to step up to the podium? Alright, so Mr. Kelly, step up and can you state your full name for the record?
My name is Matthew Gene Kelly,
All right, is there something
and
you'd like
I
to
brought
say?
my wife with me today, Christine Kelly. And I want to take this chance to express my concerns over what seems to be the lightness of this crime, that it's so big that prosecuting attorney has still got me dumbfounded on how far this went. It's not just me that was affected, but countless, I think 60, 70 some people that's been affected by this man's action. She wants to talk about missing time with the son. I've had to work double, triple shifts to be able to repay back my insurance company so I could still get my roof fixed. And I'm missing time with my wife and my own family over this. And I just want the book thrown at this guy for what he's done to me.
Does your wife want to speak today? Thank you.
Thank you, Your Honor.
Is there
And
anybody else in the courtroom that wants to speak? No.
unless anyone's on Zoom.
Gail Morris? No, I just got a divorce file.
Okay. And for the record, Kelly is spelled Kelley.
Sorry.
So we had initially had two other individuals lined up to speak. One was Melissa Samsey. She was actually the representative from No Leak Home Improvement, and she was going to speak, but her work schedule would not allow her to. But one thing she wanted to point out to the court was just how many clients they've had to placate or coordinate with, or clients and files that they've discovered have been affected by Mr. Klein when he was working with them. Money that's been paid that never made it to No Leak. Countless things that obviously aren't before the court today, but I think should be considered because these are difficult cases to investigate, and some people just, say forget about it and report to their insurance, but these are the ones that actually made it before the court. But No Leak Mr. Kelly was not the only person that they've had to deal with on behalf of Mr. Klein. The other individual who was not able to make it today was Aaron Savage. She's the victim on 2321225 FH, and very similar to Mr. Kelly. He talks about how much that he has had to work to make up this cost. The damages here, his insurance deductible going up. And I hope the court understands kind of this whole scheme that Mr. Klein had going. It's pretty severe. He severely impacted our community. He was going door to door, intentionally damaging people's roofs, making fraudulent insurance claims, or causing these people to make these fraudulent insurance claims under the guise of hail damage. If they were able to get money from their insurance company, he was taking it in cash and pocketing it. He was not ever fixing any roofs. He, again, was damaging roofs. So he's had a myriad of charges, including, as you see today, embezzlement from the company, malicious destruction of buildings for the roofs that he's damaged. The individuals just discussed and here before the court today in these files, and again, I know not everyone's here, but we have Miss Cassandra Suchman, Suchman. She had paid Mr. Klein $1,400 for materials for her roof repair. The materials never showed up. That money never made it to No Leak. She was included in one of the files. So I'm going to limit it to the people who were included in these files, but not here today. Obviously, Mr. Kelly, you heard from him. Mr. Klein told him to contact his insurance company to see if they would pay him cash to repair hail damage to his roof. His insurance company sent him $3,596. That cash payment went directly, plus a $500 deductible in cash went directly to Mr. Klein and never made it to No Leak. And obviously No Leak never fixed the roof. Melissa Samsey, as I indicated, she works for No Leak. Matthew Johns in Onstead, this was again in June 2022. Mr. Klein contacted him for a roof replacement and inspected it for storm damage. Again, the same thing that he said before, or that has been said before, that he gets on the roof and he intentionally damaged the roof. And there's been multiple roofing inspections and roof inspectors who have cited this as man-made damage. Mike Newman, same exact thing as Mr. John. This was in Pleasant Lake and was investigated by Jackson County, but was included in these reports. Aaron Savage, I indicated to him, he was on Springville Highway, same exact thing as Mr. Johns and Mr. Newman. And then finally, Anthony Jewell, who also couldn't make it today, the same exact thing, intentional roof damage that he has not been able to get fixed. So I just hope the court understands the severity of this. I understand the court did make a Cobb's agreement in this case that I think they're inclined to follow, but I would ask that in tune with that Cobb's agreement, as the guidelines are 0 to 17 now, it would be within the guidelines and within the Cobb's agreement to sentence Mr. Klein to the full 365 days in Lenawee County Jail. I think any sort of argument that he needs to be out to pay this restitution falls flat, given that we also have a child support case here where he's not paid child support. So I don't think these victims can expect any sort of restitution, which is kind of why I'm asking that we exceed the Cobb's agreement and do some sort of MDOC sentence. But I know the court doesn't like doing that. So, but I just wanted to ask, at the very least, we would ask for the full 365 days in jail. Thank you.
All right, Ms. Underwood.
Thank you, Your Honor. Your Honor, Mr. Klein understands that he seriously lost his way and went out of control. I think that's a fair thing to say. Mr. Klein apologizes to the victims in this matter, Your Honor. He understands that what he did was not right. And he understands that he has to pay for that. Mr. Klein has been in jail for some 200 days. The court did enter into a Cox agreement. Mr. Klein, Your Honor, is going to have to get out and start a job and start paying child support. While Mr. Klein has been in jail, he has availed himself of mental health services, Your Honor, and I believe is on medicine now and has a much clearer head. He will talk to you some about that. But Mr. Klein has served already 200 days in jail, I believe, right around there. It would be our hope, Your Honor, that the court, the original recommendation in this matter from the probation department, and they saw the same things here that Ms. Meir saw, was for time served, and that Mr. Klein do a rather stringent probation. We would hope the court would consider that sentence, Your Honor, and allow Mr. Klein to be released. He's going to be released at some point, Your Honor, and we think that at this point, the sooner Mr. Klein gets some stability on the outside, the better. And maybe we can get money coming to both his child and the victims, Your Honor. I know Mr. Klein wants to speak.
Ms. Brenner.
Your Honor, if you're inclined to give him additional incarceration, I would be asking for a period of monitor him for his continued, hopefully, efforts at paying the support for his child. I don't know if the court wants to know the exact amount of his arrearages. It just stated as ordered by the court in one of his conditions. I don't know if you need that exact amount or not, but
What is the child support arrearage?
it's $18,225.79, and it's accruing at $611 a month.
Okay.
So I would like to see him monitored for a period of time. I will leave the jail time to the court's discretion.
Okay, sir, you can step up to the podium. Is there anything you'd like to say on your own behalf?
Yeah, Your Honor, first off, I want to say thank you for putting me in jail. I needed this. I needed to reflect and to build myself up. I've been doing church. I was clean for almost 3 months before I got put in. I was working really hard at it. As you know, I started an NA group in here. I read 10 self-help books. I read over 65 books. I never read a book before I went to jail. I figured while I'm here, I got dirty soil, dirty roots, so I needed to start over. And I've been working out every day for 2, 3, 4 hours. I go to counseling every other week. I'm on Zoloft and Buspar. I haven't got to talk to my son not one time. My mom's mad at me. My dad's really sick. He don't come to her. Sorry. I was messing up. I was on drugs, but I did get clean on my own, and I want to continue going to NA and stuff. And I'm never really hard at it. I had a job lined up with the carpenter union. I don't know what I'm gonna do, but I was talking to Mr. Moore, and I believe I can get a truck driving job again because I still have a Class A CDL, even though my license is expired right now because I've been in here. But I will get it renewed. He said he'd help me with the rehabilitation center or something. And I talked to my counselors, and they got some programs and paperwork for me. I've really been busting my butt on this. I was being a piece of crap. I wasn't getting paid what I was promised, and I should have went through the red eye. It's my fault though. I was a crybaby, and instead of going through the right way, I took what wasn't mine, and it makes me a real piece of crap. It wasn't good to show my son that. And I'm a better man. I'm a better dad than this. And I just want to go with my dad and see my son. And I am really sorry. I was being a piece of crap. Sorry to Hannah. She's a good mom. And I worked really hard at it.
Okay.
Your Honor, I just would like to acknowledge the presence of Mr. Klein's father here to support his son. He is ill, and this was a big.
You had to walk here. You don't have a kid.
Oh, he's tucked in the corner. Okay, you moved.
You had to walk from across the county.
He was over there earlier. Okay. All
I'd
right.
like to thank him for being here, and I think it proves that Mr. Klein does have family who support him.
Okay. So in determining the appropriate sentence in these cases, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So, Mr. Klein, I know that you deny substance abuse issues, but even though I'm a judge and even though I'm stuck in a back hallway, I still read police reports. I still hear reports by people, and your name has come up quite a bit in other cases. So I know that you have mental health issues, and if you don't get your treatment, it's very easy to fall to controlled substances to treat. So I think that whether you're abusing prescription meds or using meth, it's still a drug addiction. We've been here for years with Ms. Mishinsky and trying to do what the state of Michigan believes we should do. And that is foster relationships between parents and their children and allow opportunities for both parents to be a parent, because that's what the state of Michigan believes we should do. We've done that with you for years and years and years, and you have struggled and struggled and struggled. And now it's pretty clear why. We have a host of mental health issues. We have a host of addiction issues, and you're a thief. So, I feel bad for her. I feel bad for him. I feel bad for all the people that couldn't be here today because you victimized them. I feel bad for your dad because he loves you. And it's gonna be so humiliating and sad for him to see you standing there in oranges. And it's probably breaking your parents' hearts right now, breaking Ms. Mashinsky's heart, because this is not what she wants her son to know as a father. And for the people that have had to work extra hours to try to recover from what you did to them. You've been afforded so many opportunities and you just threw them away. So it's up now. Your guidelines are 0 to 17. It is a straddle cell, which calls for a county jail term. But understand, if you violate probation, you will go to prison. So it's sent to the court that you will serve 1 year in the Lenawee County Jail on file number 22-20712FH. What is the credit now, Mr. Moore, on that file?
189 days.
You receive credit for 189 days. On all 3 files, will be placed on probation for a period of 3 years. On file number 23-20223FH and 23-21225FH, you will receive credit for time served of 189 days. On file number 22-20712FH, you'll be assessed $130 crime victim rights fee, $68 in state costs, and a $60 DNA fee. Child support still continues, so you probably need to send in front of the court a notice of incarceration.
Once.
You already did it while you've been in jail. Good for you. On file number, and then on that file, you'll be ordered to pay a monthly amount towards your arrearage, as well as your monthly child support order upon your release. Mr. Moore will provide a number that must be paid every month. That's inclusive of all of your different kinds of costs. On file number 23-21223FH, you will be assessed $4,096.46 in restitution, $750 in court costs, $450 in attorney fees, $130 crime victim rights fee, and $68 in state costs. On file number 23-21225FH, you'll be assessed restitution in the amount of $48,154.86, $130 crime victim rights fee, and $68 in state costs. You are entitled to a restitution hearing as Ms. Underwood requested. You would just have to schedule that with her. You'll pay a $30 per month supervision fee without tether, $60 per month with tether. You must comply with requirements of drug testing. I know marijuana is legal. I don't care. You have a drug addiction issue. So you're not to smoke marijuana, you're not to use any illegal controlled substances. You'll be required to test at all times. Because you're on psychotropic medications, I'm also going to order that you're not to consume alcohol, and you must comply with all testing requirements. Not to engage in any assaultive, abusive, threatening, or intimidating behavior. You must submit to search and seizure of your person, your property, your phone, your computer. Sorry, I've got now. Without need of a warrant, if they have reasonable belief to believe you have items that violate the conditions of your probation. You must not be self-employed. You owe this much money, you don't get to be self-employed, because I don't need to hear, well, I didn't make much money last month. So you must find a full-time employment. Martin Reyes hiring, by the way. You must serve jail time, as I said already. Restitution is already ordered. Let's see. I'm going to order that you have a psychiatric evaluation done if it was not done at the jail, and sign any releases to provide that information to Mr. Moore. And you are to take all medications as prescribed and attend any cognitive therapy programs that Mr. Moore believes are appropriate. Mr. Moore, am I missing anything?
Just, I wanted to clarify, we were given credit for 189 days on each file. And
Yes,
we're
but only 1 year in jail on the
correct.
first file.
Okay. Right. And just to Mr. Klein, upon your release, you come see me the following business
All
day.
right. So when you get out of jail, they usually let you out like midnight or something. You will wait, and the next morning at 8 o'clock, you better be at the courthouse.
I have for the child support one, that's what I'm getting a year for, right? I have 2 weeks. I was in jail for over 2 weeks for that charge. And
You'll
took
get
off.
credit for whatever you're entitled to. So if there's more credit on that file, you'll get credit for it. All right, so my bailiff's gonna hand down to you for each file a notice of right to appellate review. On each file, I need you to initial and date the top copy. That's gonna go back in my file to acknowledge that you received your paperwork. If you wish to appeal your sentence, you would fill out the information on each of those, or one of them, whichever file you would like to appeal, and provide it back to the court. You can send it through a kite or mail it in within 42 days. Right, the record should reflect, I received back the signed copy of the notice of right to appellate review. Ms. Brenner, Ms. Meir, Ms. Underwood, thank you. Everyone have a good day.
Thank you.
Adam, I think I might have brought you back to the divorce file. Guys, you're outside unless you want to talk to me here. Mayor, Ms. Underwood, can you approach? Yeah. Over here. That's why I know. That's why. All right, thank you. Okay. All right, so we are, oh, there you are, come back up here. I almost tried to have him give a victim impact statement earlier, but Mr. Morris kind of looked at me, I was like, oh. Okay. I had a bunch of victims in the courtroom and Mr. Morris was in the courtroom and I almost forgot who he was for a minute and was gonna have him come up and make a victim impact statement. Okay, so, we are back on the record in the matter of, so let me find you guys again. Kayla Morris versus Edgar Morris. Mr. Morris had a few questions and I had a bunch of sentencing, so thank you both for being willing to come back in now. Mr. Morris, have you had a chance now to speak with Ms. Iddings?
Yes.
Okay, Ms. Iddings, do you feel you and your client are in a good place to continue this today?
I do, Your Honor. There were a couple of things I explained to Mr. Morris, as you had stated as well, that if he has concerns about some things that were in the judgment, those would be post-judgment matters, and I explained that to him. So I think we're on the same page. He understands that the judgment is written and signed is what they agreed to. If he has problems later with Ms. Morris following through on any terms of the divorce judgment, then that's something that would be a post-judgment